Well, Australia's casual workforce is set for a massive payday after a landmark court decision ruled that they are entitled to paid leave. A decision exposing employers to back pay claims worth up to $8 billion. Joining us live via Skype from Sydney is Joydeep Hoare. He's one of Australia's best-known workplace relations lawyers and the founder of People and Culture Strategies and a friend of AusBiz here. Joydeep, we just need to be clear with what's happened, don't we? Because it's not that every casual employee is entitled to paid leave, is it? It's the casual employees who've been working, in essence, shifts as if they're regular employees.
That's right, Nadine. I think in order to understand the significance of this decision, you need to understand the basic framework of what is casual employment versus permanent employment in the context of leave. And the way it works is that if you're a permanent employee, whether you're working full-time or part-time, then you have certain entitlements at law. Now, those entitlements could come to you via the Fair Work Act, they could come via an award, they could come via an enterprise agreement. And those entitlements will include things like annual leave, sick leave, compassionate leave, and numerous other things. Now, if you're a casual employee, you don't officially have a right to any of those things. Instead, a casual employee legally is entitled to a loading of 25%, which is designed to compensate that casual employee for the things that they're missing out on. Now, the significance of this particular decision was in respect of one employee who was working for his employer for a period of 3.5 years, labelled as a casual. But the court had to look at, well, in circumstances where this particular employee was working a very regular pattern of work, for all intents and purposes, there's really no difference between looking at how he worked and how a permanent employee worked. Was it fair? Was it equitable? Was it the legal position, and should it be the legal position, that that particular worker should miss out on all of those entitlements that those permanent employees got? And in this particular case, the full bench of the federal court said no, in spite of the fact that his contract clearly stated that he was a casual. And in fact, the contract said that this loading of 25% that you're going to get is attributable in some component to annual leave, some component to sick leave, all of those things. The court said no. We have to look at whether this employee was truly working as a permanent employee. Our view was that he was, and because of that, he is entitled to all of those benefits that a permanent employee should get. So,
Jody, now that we've had this ruling, where does it leave casual workers and also businesses when it comes to going and settling this claim?
Yeah, so I think, and Nadine, to your earlier point as well, while some might say that this is a windfall for all casual employees, that's not the case. What this tells us is that if you're a casual employee working in an organisation and you can show that there has been this regularity and longevity, and by longevity you're really looking at something probably north of 12 months, and there's basically a guarantee that you have, if you look at your working arrangements, that you have work. In that particular case, the court is, off the back of this particular ruling, likely to be inclined to find that you are entitled to a lot of those things that at the moment you're probably not getting, and even though you're getting a loading instead of those things, you may well be entitled to both the loading and all of those things.
So, Joydeep,
so the lesson I would say...
Go ahead, Joydeep. What's the lesson?
Yeah, I was going to say that the lesson here for employers is you need to look very carefully at your workforce. And yes, you might have a pool of people who you are treating as casuals, and you might be relying on the fact that their contracts say that they are casuals. But this ruling should be a stark reminder that if challenged, what you've said in your contract is going to be irrelevant. A court will look at how is this person engaged, how are they working, and if their view is that looks like a permanent, smells like a permanent, doesn't matter what you've called them, we're going to give them the benefit of permanent employment.
This sounds pretty big. So is there any way that employers can rectify the situation with some of their casual employees, that have been treated pretty much like a permanent employee, in the meantime, without perhaps going down the route of paying back everything?
I think there'll be a lot of employers who will be wanting to explore that. It's difficult because on the one hand, this is a matter of individual contract and the right of an employee to certain benefits under their contract and at law. But it's also a question of whether an employer has complied with that employer's obligations as a matter of law generally. And if it's found that they haven't, leave aside what the wishes of that individual might be, they could still find themselves the subject of prosecution from the Fair Work Ombudsman and other authorities. So, yes, you might be able to do a deal, to be blunt, with the individual casual employees whose employment is being scrutinised or potentially being scrutinised here, but that might not absolve you of all of your liabilities. So, look, employers at the very least should be doing an audit. They should be aware of exactly what could be the scope of back pay that potentially might apply in relation to them, take careful advice in relation to what are the appropriate strategies and legal issues that are involved here, and then absolutely come up with a plan. And it's one of those ones where even if employers try to mitigate somewhat, that could actually go a long way and avoid the pain down the track.
Yeah, right. Okay, Joydeep, thanks for getting us across that. Really appreciate your time as always.
Appreciate it. Thanks for having me.